14-year-old T.L.O was found smoking a cigarette in her school bathroom with a friend. The teacher who found them took them to the principal's office. They met with the assistant vice principal, who questioned them. T.L.O denied smoking in the bathroom, and the assistant vice principal demanded to search her purse. In her purse, he found not only cigarettes, but also cigarette rolling papers associated with the smoking of marijuana, a pipe, plastic bags, a large amount of money, a list of students who owed T.L.O money, and 2 letters that implied T.L.O's involvement in marijuana dealing. The state pressed delinquency charges in juvenile court. T.L.O was represented by Lois DeJulio. The petitioner was represented by Alan J. Nodes. In court, they denied T.L.O the right to suppress the evidence found in her purse and held that the Fourth Amendment applies to school officials. However, the search was reasonable and justified. The Appellate Division of the New Jersey Superior Court agreed that there was no violation of the Fourth Amendment and dropped the charges of delinquency and sent the case back to the juvenile court. The case was then forwarded to the New Jersey Supreme Court, which decided in favor of T.L.O and ordered the suppression of the evidence in her purse and that the search was unreasonable. The case then made it to the Supreme Court of the United States, where T.L.O was charged for the contents of her purse, and the court decided the search was reasonable and did not violate the Fourth Amendment.
New Jersey versus T.L.O involves students' Fourth Amendment rights and personal privacy. Cases that relate to New Jersey versus T.L.O involve students' possessions getting searched, such as lockers, cars, and bags. A recent case in 2009 utilized the ruling on New Jersey versus T.L.O. In the more recent incident, an Egg Harbor Township assistant principal, Peter Brandt, searched the locker of an 18-year-old student, Thomas Best. The search occurred after the teenager allegedly dealt a green pill to another student. After the locker search, the assistant principal found nothing and thus resorted to searching Best's car, where he discovered a bottle of pills as well as marijuana. Best faced charges of possession of Valium, marijuana, and steroids. The case was brought to the Supreme Court, where Best's lawyers argued that a police officer should have searched the car rather than a school official. The reason stood the same as the 1980 case, stating that if there is reasonable cause, the school officials should have the right to search students' possessions. In addition to this, we do believe that there has been a multitude of other cases where New Jersey versus T.L.O has been brought back up, but none of them have been as significant as this one to make it pass to the Supreme Court and get media attention.
We agree with the Supreme Court ruling because the school official had reasonable cause to search T.L.O's purse. She had denied smoking in the school bathroom, and the assistant principal was searching for evidence to support the teacher's accusation. It just happens that in the search for the cigarettes, the assistant principal found marijuana and marijuana paraphernalia. The reason the Fourth Amendment doesn't apply to students in school settings is because students surrender certain rights when they enter the school building in order to keep themselves and other students safe. If a school official suspects a student may be in possession of something that could be dangerous to other students, such as illegal substances or a weapon, then they have the right to search the student and their belongings, or if, in T.L.O's case, they break a school rule. The Fourth Amendment does not apply in school settings in order to keep students safe and to enforce school rules, so T.L.O's denial of smoking the cigarettes gave the assistant vice principal reasonable cause to search her purse.
This case impacts us today, specifically because we are in the same age group as the student involved in the case, and we are in the same school environment daily. This means that if something happened to us where we were suspected of possessing something against school rules, our basic Fourth Amendment rights are pretty much revoked while on school premises in order to protect the rest of the school. In all instances where this case has been brought back up, the court has stuck with its ruling, saying that searches by school officials are completely legal, so we don't see this ruling being changed in the near future. Also, the case has gone through 4 courts and has been thoroughly reviewed, so the ruling is most likely going to stand. However, we can see this case being brought back up in the future in a similar instance to the case in 2009, where a student could get their car searched. Most people would have a greater problem with a car search since it is their property, and even though it is on school property, it isn't in the school building affecting any other students at the time.